I want to talk a little bit about the arbitration and mediation process in New York State. Most of our cases are in the New York State Supreme Court, which is our trial court in New York. And when we proceed through that venue, we go to a trial in front of a jury. There are areas and times when we can enter into alternate dispute resolution. An alternate dispute resolution comes about in two major forms. Number one would be mediation. And the mediation is either done through the court system or private counsel, where we bring the parties in an attempt to secure a number that we think is reasonable. And having a third party, non-biased person involved in that oftentimes will help. Other times, we can actually engage in arbitrations, which is a binding process. So by example, recently I had a case where we decided to go into a mediation posture. And during that mediation posture, we hired an attorney who acted as a go-between between us and the insurance company and their lawyers. And we did this instead of going to trial on this case. And we'd make that determination on a case-by-case basis. In this case, by going through a mediation process, it allows us to refrain from hiring sometimes very expensive doctors, and in this case, probably 4 doctors or 5 doctors and an additional $60,000 of cost to try the case. The insurance company in this case had offered us $100,000 to settle the case, and they were confident that that number was a number that a jury would give. We provided a detailed explanation of all of the medicals with our experts and our financial position to the mediator. So did the other side. While we were in the mediation process, and as a result of our papers, which the mediator indicated were compelling, we were able to quadruple that number in one day. We came into a range that ultimately I felt was the range that I thought was reasonable. It was actually a little higher than I thought was reasonable. And we were able to settle the case without having to proceed through the jury trial and with all of the costs associated with that. Now, we do this in some cases, not all cases. It's just a feel as to whether or not the insurance company will be in a position where they can be moved off of what would otherwise be a staunch position.